I'll start off with a question. The Affordable Care Act ruling by the U.S. Supreme Court was confusing, certainly to a non-lawyer. What I believe they said, the federal government under the Affordable Care Act said, states are going to receive all of their Medicaid funding. They're going to have to expand the Medicaid eligibility up to 138% of the poverty level. If not, we're going to pull all of our money. And the court, I believe, said that was unnecessarily coercive, an abuse of the spending power, and said you can't tie those two things together, these substantially funded programs. Federal government likes to do that with speed limits, with transportation money. Can this precedent be applied to other areas of federal spending? For example, Common Core is a controversial issue with education. Can the federal government now say, we're going to pull your Title I money, for example, if you don't implement Common Core? Is that a precedent that can be applied?
Well, I won't give you my own personal views on the law, but as I understand the ruling, and it was, people lost in the fact that the Affordable Care Act got upheld as a tax, lost the fact that a majority of the court, for the first time ever, put a limit on the federal government's use of the spending power to attach conditions. The court had, in cases over the years, including one on speed limit laws, attached conditions, and the court had always said, well, at some point the government might go too far. This was the first time, I think as Chief Justice Roberts put it, the effect of the Medicaid portion of the Affordable Care Act was like pointing a gun at the head of the states. So there is going to be some limit. Exactly where that limit is drawn is going to have to be sorted out in future cases. But, a lot of times the most important things about decisions like that is they're just kind of warning shots to the legislature that there is a point if you go that will be too far. And that, I think most legislators try to comply with their understanding of the Constitution and the laws, and they will understand that they want to try to do things that keep things that aren't going to be subjected to potentially getting shot down. So how it applies, there certainly is a lot of leeway for the federal government to say, if you want our money, you're going to have to do certain things as a condition. But for the first time ever, the court said there is a limit to that. And if basically we're giving you money, but the costs of taking it and complying with these conditions go, particularly if they go beyond that pot of money they're giving you, that may be struck down. So that, again, kind of lost in the debate. That was a huge change from the court as it had been since the New Deal, where basically the government could tell states to do almost anything as long as you wanted to get the federal government's money.
I have a question.
Yep.
Can you hear me?
Yep.
My name is Jeffrey English. I'm a physician in town and do some political things. And I have a question for you. I first of all respect and enjoyed your statement how you interpret existing laws and you don't alter them. And I think we would all love it if all judges did the same thing. So in that vein, my question is on the Affordable Care Act and the Oklahoma lawsuit on the giving subsidies in the federal exchanges in the states like Georgia as opposed to the state exchanges that are set up by the states.
What's exactly the question there?
So the question. So the Oklahoma court again that will likely go to the Supreme Court is stating that the federal exchanges cannot give the same subsidies that the state-based exchanges could. Therefore, it nullifies a lot of the requirements of the ACA in those states.
Yeah, I mean, I'm only kind of following this in the news and the legal journals, but as I understand the issue, the federal exchanges are funded, but you don't get, at least the law as written didn't contemplate that states weren't going to set up their own exchanges. The administration has, as a matter of interpretation of its administrative authority, extended what the law said. Whether that holds up, I think, will be a very interesting question. I mean, one of the things about, again, people lose in the discussion of court cases is the Affordable Care Act got upheld against a challenge that it was invalid under the Commerce Clause. Actually, it got struck down on, well, not approved on Commerce Clause grounds got upheld as a proper use of Congress's authority under the taxing power. And by the way, if the Affordable Care Act had been clearly set up as a tax, there really wouldn't be much question that it could have been upheld. The controversial question was when people said it wasn't a tax, but it kind of operated a lot like a tax, is that good enough? But lots of other challenges to the Affordable Care Act and its provisions still remain. The one you just mentioned, there are many challenges to, under the religion clauses of the Constitution, to whether the Affordable Care Act can mandate certain things in insurance when that may conflict with individuals or the owners of businesses, religious beliefs. So there are lots of other parts of the law that are still subject to attack, and that's going to be played out in a series of cases. So, you know, I always find it somewhat amusing when people kind of celebrate that everything's just fine when there are lots of people still challenging a lot of parts of the Affordable Care Act.